Oh, that's where you wanted to be.
Want to call to order the 9th meeting of the Senate State and Local Government Committee is called to order. Madam Secretary, please call the roll.
Senator Rocky Adams, Senator Chambers Armstrong, Senator Herron, Senator Maiden, Senator Mays Bledsoe, Senator McDaniel, Senator Mills,
Here.
Senator Rawlings, Senator Tishner, Vice Chair Elkins,
Present.
Chair Nemus.
Present. Please remember to silence your cell phones during the meeting when explaining your vote. First cast your vote, then explain. The first item on the agenda is House Bill 321, sponsored by Representative Johnson. Please introduce yourself, and you have the floor.
Thank you, Mr. Chairman. My name is DJ Johnson, State Representative for the 13th District.
Gracie Kelly, the Director of Government Affairs for the Kentucky League of Cities.
You have the floor.
Thank you, Mr. Chairman. House Bill 321, first thing I'll mention is there is a committee substitute. Would you like to act on it now?
All in favor of the sub, say aye. Aye. All opposed? The sub has been adopted.
Thank you, Mr. Chairman. House Bill 321, as amended, does three things. I'll cover the first two things, and then I'll hand it over to Leader Mills to discuss what actually was in the committee substitute, and we'll just go from there however you like. House Bill 321 does, as I said, three things. First thing it does is in order to enable more individuals to serve on local planning commissions, 321 gives appointed members of planning commissions and boards of adjustments a longer period of time to complete initial orientation training, and expands the time frame for completing existing continuing education requirements. More importantly, the second thing the bill does is it adds in a new requirement that both appointed members and staff to receive training that focuses on the impact of planning and zoning policies and procedures on housing, supply, and accessibility. This change will mandate that individuals receive at least 1 hour of training focused on housing at both the initial orientation and for each period of continuing education. I will finish with that KLC, KACO, and the Kentucky Realtors Association are all in support of the bill.
We have a motion and a second. Is there discussion? Did you want to discuss the sub, or you want to vote?
I would hand it over to Leader Mills.
I can clarify what the sub is. The sub, this came out of the Housing Task Force. One of the things that we heard from the Housing Task Force was some of the delays involving development and business and subdivision development had to do with people holding up litigating development in certain areas of the state. So the committee sub says any person or entity claiming to be injured or aggrieved by any final action of a board of adjustment and that owns real property within the same zone where the property that is the subject of the final action is located shall appeal that action to the circuit court. So this limits the ability to litigate development concerns to people that are in that same zone in the city or county.
I have a motion and a second on the bill. Is there any more discussion? Madam Secretary, please call the roll.
Senator Rocky Adams, Senator Chambers Armstrong.
May I explain my yes vote, Mr. Chair?
Yes, please.
I'm going to vote yes. I don't have any initial concerns about the sub-language. I haven't had time to consider it, and so I reserve the right to change my vote on the floor if I learn of concerns down the road. Thank you.
Senator Elkins,
Aye.
Senator Herron, Senator Maiden, Senator Mays Bledsoe, Senator McDaniel, Senator Mills,
Aye.
Senator Rawlings, Senator Tishner, Chair Nemus.
Aye. The measure passes House Bill 321, 8-0, and should do so on the floor. Thank you,
Mr. Chairman. Thank you, committee members.
We have a title.
Motion on title amendment.
Is there a second? All in favor say aye.
Aye.
Opposed? Title amendment has been adopted. The second item on the agenda is House Bill 340, sponsored by Representative Hampton. Please introduce yourself and your guest and continue.
My name is Tony Hampton. I'm representative for the 62nd District, Scott County.
Pat Morgan with the Kentucky Sheriff's Association on behalf of Jerry Wagner, who could not be here today. He's with Grandparents' Day.
My name's Brian Taylor. I'm a law enforcement liaison with the Defense Counterintelligence and Security Agency.
I'm Sean Butler. I'm the Executive Director for the Kentucky Police Chiefs Association.
You have the floor.
Thank you, Chair. Thank you, Mr. Chairman and committee members. Today I'm here to speak on House Bill 340, Federal Background Checks. This legislation will change and create a new section of KRS 7, Chapter 13 to define terms and require criminal justice agencies to provide criminal history records information for requesting agencies when they're conducting a basic suitability or fitness assessment for potential federal or contractor employees. Current federal law, 5 U.S. Code Section 9101, requires local, county, and state criminal justice agencies to comply with the current U.S. Code when a federal agent or contractor produces a signed, released copy by an individual who is seeking employment with a federal agency. These individuals are seeking employment, a security clearance, or access to secure federal facilities. Information that the federal agents or contractors are seeking to obtain are the actual case files maintained by the local investigating agency. This will allow local, county, and state agencies to request a fee of $25 for criminal records information. This will amend KRS 610.340 relating to the juvenile justice records to conform. Reimbursement will be paid by the federal government to the agency. Members of the Department of Defense have spoken the past year at the KCP and KSA conferences to help with compliance of 5 U.S. Code Section 9101. This fee does not come from the Kentucky Treasury. The background and suitability screening are signed by the individual who is seeking employment within a federal agency, allowing them to receive a security clearance or access to a secure federal facility. With that, I'm glad to answer any questions or have my guest answer any.
We have a motion and a second on the bill. Is there any discussion? Seeing none, Madam Secretary, call the roll.
Senator Rocky Adams, Senator Chambers Armstrong, Senator Elkins,
Aye.
Senator Herron, Senator Maiden, Senator Mays Bledsoe, Senator McDaniel, Senator Mills, Senator Rawlings, Senator Tishner, Chair Nemus.
Aye. House Bill 340 passes 9 yeas, no nays, so we expect it to do so on the floor.
Thank you, Mr. Chairman and committee. Thank you.
The last item on the agenda is House Bill 520, sponsored by Representative Fugate. Please introduce yourself and your guest.
Yes, sir. Thank you, Mr. Chairman. Chris Fugate, 84th House District.
Pat Morgan with the Kentucky Sheriff's Association.
Sean Butler with the Kentucky Police Chiefs Association.
J.D. Cheney with the Kentucky League of Cities.
Thank you, Mr. Chairman. I think you have a committee sub.
Motion on sub.
All in favor?
Aye.
Opposed? Sub has been adopted. Continue.
Thank you, Mr. Chairman. House Bill 520 and the committee substitute, it deals with the Open Records Act concerning open police investigations. In my experience as a Kentucky State Trooper and / detective, there were times when I would work cases where the case would start in my home county, but then would lead up to the state of Ohio, then it would lead up to the state of Michigan. This open records request, or this bill, House Bill 520, would keep the open records from being, or parts of our investigation from being received from different people or agencies while the investigation is ongoing. It protects the investigation. It protects witnesses. It protects confidential informants, and it also protects the life of the police officers. When investigations are compromised, you obviously know that people can be hurt, injured, or they can even be caused to not be a witness anymore. So this bill would protect the police from having to give records that would compromise their investigations until the end of the investigation, until the court system is finished with the case.
Senator Tishner.
Thank you, Representative Fugate. I have a few questions and concerns about this bill. This bill is essentially changing our open meetings laws. Am I correct on that?
It is dealing with the records and reports that deal with open investigations by police.
Right, which is a part of the Open Meetings Act. Have we ever made changes to our Open Meetings Act since it was established in our KRS?
I'm not aware of any.
I know there was a measure last year to try and do the same, and there was great opposition from the people because it's a matter of government transparency, and the whole reason we have the Open Meetings Act from the beginning, that we are transparent to the public. And
Yes,
I think loosening that is not a good thing to do for the public. Some of these investigations can be open for quite some time. Am I right?
Correct. That's correct.
Can you also? So I'm so sorry, Mr. Chair. Can I ask another question?
Yes, please.
I'm sorry, I'm just rambling on. It says records of law enforcement agency or agencies involved in administrative adjudication. What other agencies could those be?
It could also be the Attorney General's office.
Okay. Okay, thank you.
Senator Elkins.
Thank you, Mr. Chair. I have two questions, if you will.
Yes, sir.
First question comes from where it states the agency states that disclosure of information could pose. So when you say agency, exactly what does that mean? And then have you considered language that would read would pose rather than could pose? Because could pose is pretty open.
Yes, sir. I understand that. In the original bill, it was the word would. The Senate committee sub would change it to could. And again, looking from my law enforcement side of it and the experience, an investigation, especially in the drug investigation world, could last up to a year and a half to 2 years. We would do drug investigations and have probably 20 people that were targets of the investigation that we'd purchased drugs from. If during that investigation someone did an open records request and got the copy of the tapes, the names, the witnesses, then I could have never rolled that case on up to the Dayton, Ohio area. The same would apply to Dayton, Ohio. Then I could have never rolled it up to Detroit, Michigan. And that's an actual case that we worked. And that case took a year and a half to 2 years. And it was important to keep those records. And I'm all for transparency. In my time at the state police, I was part of investigations in other police officers and made arrests on other police officers. So I'm for transparency. But when it comes to the cases that are active, again, when I was working in the drug field, the troopers that I worked with, I didn't even tell them what I was doing. Nobody knew what we were doing as a drug investigation other than our supervisors, obviously. Just because when word gets out on the street, then the people who are doing the case, the investigations, their life is in jeopardy. And I understand transparency, and I understand, it's important to be transparent, but also know that a murder investigation or a sexual abuse investigation or other investigations need to be held close to the cuff, so to speak, so that the witnesses and those that are involved in the investigation would not be in danger.
Senator Chambers Armstrong.
Thank you, Mr. Chair. I voted no on the sub just now that we've adopted and is before us because I'm really concerned about the way it seems to broaden the exemptions that were even in the underlying bill, and I just want to make sure that I'm reading it correctly and its impact correctly. So in the sub, it says that if an agency states that the disclosure of the information could pose a risk of harm to the agency or to its investigation, right? So either the agency says this will hurt us or this will hurt our investigation by revealing the identity of informants or witnesses, et cetera, et cetera. I read that. So I practiced open records law for a while before running for office, and it used to be that it was a court that determined under this if it would pose a risk of harm. And it was not enough for an agency to say this will pose harm. If they said that, they would go to court and a court would decide if it actually poses a risk of harm. Am I reading this correctly that under this, if an agency just says, I believe this would pose a risk of harm, that alone is sufficient to be able to withhold and there's no role for a court to question that determination?
Well, thank you for the question. I believe that if you read the entire section, it says if the agency states that the disclosure of the information could pose a risk of harm to the agency or its investigation by revealing the identity of informants or witnesses. It doesn't just say that for any reason you could pose that or say that it's a danger, but for the reason of identifying witnesses or informants, that absolutely does, not only could, but it does hinder an investigation.
Senator McDaniels.
Thank you, Mr. Chairman. And Representative, I think the underlying statute may answer the question, but basically you're holding on to records that are not subject to an open records request, but it says records shall be open after enforcement action is completed or a decision is made to take no action. So basically, yes. I don't know if enforcement action means like a full adjudication or not, or if it just means when it goes from law enforcement to the court system. But there is a point in time where these become subject to open records.
Yes, sir, there is.
They're not forever bound. All right.
Yes.
Thank you, Mr. Chairman.
Senator Mays Bledsoe.
Thank you, Chair. And Senator McDaniel was going to ask a very similar question. Alon, there is no timeline, correct? So if an open investigation is open, it's open for or closed for several years before it could come to that conclusion.
Again, in my experience, when a case goes to court and the court proceedings are finished and the witnesses have testified, then those records would be available. And even sometimes before on cases that I worked, informant information was made known.
And I completely understand the underlying premise of what you're going for. In Lexington, I can talk about specifically how important some of those holding it close, being mindful of dominoes is important for everyone involved. So I support all of that in the intentions. I do worry about opening up some of these things maybe broader. And Mr. Cheney, if you have a thought, please share it.
Thank you, Senator. This maintains the language in that last paragraph that the exemptions provided by the subsection shall not be used by the custodian of records to delay or impede the exercise of rights granted under the Open Records Act. That maintains that language that it can't just be used as subterfuge to deny access to the records.
Okay, thank you.
Senator Elkins.
So I'm still struggling with the balance of protection, which I certainly understand, and transparency, which I certainly feel like we need, and I'm always hesitant to restrict or limit transparency, although I do understand the need to protect your investigation. I just am not. I still struggle with the word could, in that seems too broad to me. And the instances that you described certainly I think would qualify as would damage or hurt your investigation or your ability to investigate. The word could, I think, just opens it up and makes it too broad. So I'm going to ask you to think about that. And Mr. Cheney, if I may, you care to elaborate on what you just said, because you may help me answer my question.
Yeah, and that's a key change. Is that was switched to would. So what is required right now of law enforcement agency is to prove that it creates a concrete and tangible harm during the course of the investigation. So in many cases, you have to state what that harm would be, which would thereby disclose and defeat the very purpose of the Open Records Act. If you have to prove that it assuredly would damage the investigation or assuredly would release the names of informants by the premature release, then you have to provide enough details on the investigation that it might undermine. We agree with you all that this is a balancing act between the public's right to inspect, but when you have to do that concrete proof that it would harm it, instead of, listen, when you're in the investigation process, it may or may not be, you may not know yet whether that release of information is going to cause the harm. That's the changing of the word.
Senator Chambers Armstrong.
Thank you, Mr. Chair. Isn't it true, though, that currently what happens is if someone makes a request for records related to an investigation and law enforcement says this would harm our investigation, there are processes for a court to review those records in camera away from the public eye. Am I correct about that?
Yes, Senator. You are. Now, first, generally, you don't have to exhaust administrative remedies. Generally, it would go to the Attorney General's office. Most people do that, and then it would go to the circuit court. But with the wood standard, rather than having that adjudication, you're having to do every one of those. Every one of those cases are subject to that analysis in camera to view. So any request for law enforcement under this exemption with the wood standard is almost kicking every one of them to in-camera review.
Can I have one quick follow-up, Mr. Chair?
Yes, quick, please.
So what concerns me, though, is that process where a court decides, agency, are you correct that this falls under the Open Records Act, is being eviscerated in the sub, because all an agency has to do is state that it's in its belief it falls into this exception. A court doesn't have any oversight over that. The Attorney General doesn't have any oversight on that. Help me understand how this doesn't let law enforcement or the agencies enforce the Open Records Act.
Senator, the appellate process would remain the same. And as Representative Fugate pointed out, if you state that it could cause a harm by the premature release of information, harm the investigation, harm witnesses or informants, then there's still the appellate procedure to the Attorney General's office or to the circuit court. It does not take that ability away for the requester to do the appeal.
Seeing no further discussion or questions, we have a motion and a second. Madam Secretary, please call the roll.
Senator Rocky Adams. Senator Chambers Armstrong. Senator Elkins.
Explain my vote, Mr. Chair.
Yes, please.
So I'm reluctantly going to vote no. I like what you're trying to do. I'm just not sure we're getting there the right way. And I support you continuing to get there. I'm not sure I support how we're doing it. So I'm going to vote no.
Senator Herron. Senator Maiden.
Explain my vote.
Yes, please.
I'm an aye, and I'm certainly for transparency. As my former life, everybody knows I was the mayor, but I also sit on the side of Mr. Fugate. And when I had to protect police officers that were in drug investigations that were nationally criminal syndicates that we try to protect our police officers. So while I'm for transparency, I'm also for protecting our police officers. I'm a yes.
Senator Bledsoe.
I vote and explain.
Yes, please.
And thank you, Mr. Chairman. I'm going to vote aye and allow the conversation to continue because I think it's an important one and a valuable one to have. And the concerns that are raised, I think it's a balancing act. And I think we need to continue talking about it a little bit further.
Senator McDaniel.
Cast my vote and explain, Mr. Chairman.
Yes, please.
Cast an aye vote. Up home, we had a situation actually just over in the Ohio River, although people accuse me of representing Cincinnati. I don't. But there was a situation over in Pike County not several years ago where one morning there were like 11 or 14 members of a single family that were killed in a custody dispute. And it literally, the investigation spanned 7 or 8 years, went all the way up to Alaska to find some of these people, then have them brought back to justice in Ohio. I mean, these are people who are willing to walk in and murder children in cold blood, right? And the idea that records necessary to go, extradite these folks from literally the far edges of the nation and bring them back, and the length of time it takes, and what would have happened if these records had been out there. Certainly, while all of us are entitled to justice and entitled to a knowledge of what occurs, the unfortunate nature of when you're dealing in proceedings like this is sometimes the people that you deal with are far more of a danger to the overall administration of justice in our society than is the delay in the release of the records. And so the balancing act is what it is, but we're talking about a space that gets very dangerous very quickly for victims, for law enforcement officers, and frankly for other members of the community for whom these folks remain at large or could permanently remain at large in the event that one of these investigations gets compromised. Thank you, Mr. Chairman.
Senator Mills.
Explain my vote.
Yes, please.
Mr. Chairman, I vote aye. And this is a very complicated issue, and it was nice to listen to the conversation here. But I like what the bill does, the protections that it affords to law enforcement. So I vote aye.
Senator Rawlings.
Comment on my vote?
Yes, please.
I'm sorry, but I'm going to vote no. I'm just hung up on the word could in the comments that were previously made. Thank you.
Senator Tishner.
Cast my vote and explain, please.
Yes, please.
Again, Representative Fugate, I do appreciate what you're trying to accomplish here. I think there's just that word could is too subjective in my mind, and it just depends on who's going to look at this case. And considering how long cases can be open, we're leaving people in transparency just hanging. And I would be much happier if we could stick with would. The other changes in the bill don't bother me. It's just that one word that gives me pause. So I vote no.
Chair Nemus.
Aye. House Bill 520, as amended by the committee substitute, fails. Hold on a second. At this point, with the
Chair, can I register my votes?
Mr. Chairman. Mr. Chairman.
Is there any member that wants to cast or change their vote before we call this? Senator Herron.
Yes, I'd like to cast a no for 520.
Anyone else? No, you can.
Mr. Chairman. Mr. Chairman. Could I say one thing?
Yeah.
Could we drop the committee sub and go back with the original House Bill 520?
It's already been adopted.
Mr. Chairman, if I may.
Yes, Senator Hawkins. Yes, Senator Hawkins.
Mr. Chairman, I'll change my vote to yes to move this bill along and continue the conversation.
Any other members want to explain, change their vote? 6-5. House Bill 520, as amended by the committee substitute, passes with favorable expression 6-4. And we'll move on to the floor.
Thank you, Mr. Chairman, members of the committee.
Mr. Ch- oh,